Welcome back to the deep dive. Today
Right.
we're wrestling with a question that really sits at this incredible intersection of history, law, and morality.
That's a huge one.
It really is. How do you legally define and prosecute evil on a scale that was, before this, completely unimaginable? I mean, you look at the sheer weight of the crimes of Nazi Germany.
The systematic mass murder, the wars of aggression.
Exactly. The total disregard for human life. The task of subjecting all of that horror to the cool, measured rules of a courtroom. It seems impossible.
It feels like trying to contain a tidal wave with a teacup.
That's the perfect analogy.
Yeah.
And that contrast, that tension, is precisely what makes the International Military Tribunal, what we all know as the Nuremberg Trials, so compelling.
And you have to remember the context. World War II ends in just this profound state of exhaustion. But for the Allies, the US, UK, France, and the USSR, there was this immediate, daunting requirement.
The architects of the Nazi regime had to be punished.
They had to be. But punishment alone was not enough. They had to prove, for history, that this was a legitimate legal reckoning.
Not just vengeance.
Not just vengeance. They had to actively dispel those inevitable accusations of vindictive victor's justice.
And that's the core challenge we're unpacking today. Our mission, really, is to take you inside the opening of those trials, which began on November 20, 1945. We're going to look at the revolutionary legal structure they had to forge, the 4 core charges that literally invented modern international criminal law, and the dramatic, unprecedented strategy the prosecution used.
A strategy that was designed to convict the highest-ranking perpetrators using, for the most part, their own words.
Exactly. We want you to walk away from this with a real understanding of the meticulous, almost audacious effort that went into proving the systematic criminality of the Third Reich.
And we have to start with the environment. The trial was held in the Palace of Justice in Nuremberg, Bavaria. And that wasn't a choice made lightly.
Right. I mean, Nuremberg carries this immense symbolism. It was the host city for those gigantic, infamous Nazi Party rallies. But beyond just flipping the script, how did holding it there actually serve the goal of legal legitimacy? Didn't that symbolism risk undermining the sober, factual nature of it all?
That's a profound point, and the symbolism was deliberately twofold. On one hand, yes, it was the ultimate act of public humiliation for the regime.
Holding the reckoning where they celebrated their darkest power.
Precisely. But on a practical level, Nuremberg just happened to have the least damaged large courtroom facility in all of Germany. It was capable of housing the hundreds of personnel, reporters, and, critically,
Mountains of documents.
the mountains of documentary evidence required. So it served that public statement, that their lawlessness was now subordinate, but it also provided a functioning, intact infrastructure. It was necessary for that long-haul commitment to due process.
That dual purpose is fascinating. The functional meeting the philosophical. And the trial lasted for, an astonishing 293 subsequent days.
It was a marathon.
It was. So considering the political urgency and the chaos right after the war, why was such a long trial necessary? Why did the Allies reject simpler solutions like, say, summary executions?
Well, the rejection of summary execution, which was initially favored by figures like Stalin and even some in the British government, that rejection was central to the entire endeavor.
Because if they just lined them up and shot them.
They would become exactly what they claimed to despise, arbitrary executioners. The challenge was all about maintaining legitimacy for posterity. The ultimate purpose wasn't just retribution. It was about constructing an irrefutable public record of the horrific crimes committed.
I see.
And that required rigorous evidence, meticulous cross-examination, and judicial due process. It was about demonstrating to the world, and just as importantly, to the defeated German populace, the systematic and documented criminality of the regime. The trial itself was intended to be a historical document.
So the trial was not merely seeking justice for the victims. It was building a documentary firewall against any future historical revisionism.
Exactly. The ultimate assertion of facts over ideology.
Wow.
And the sheer mass of evidence presented is what gives Nuremberg its enduring power today. It's what allowed the American chief prosecutor, Robert H. Jackson, to argue that this was the moment when, perhaps for the first time in history, power has ever paid to reason. They needed the world to watch the evidence unfold and come to the verdict themselves.
Okay, so let's unpack this architecture of accountability. When you have 4 sovereign nations, each with wildly different legal traditions.
That's the key. Common law, civil law, the Soviet inquisitorial system.
Right. How do they even begin to agree on the nuts and bolts of the tribunal? who were the key players that hammered out this revolutionary structure?
Well, the International Military Tribunal, the IMT, required incredible legal flexibility. It was composed of 4 primary judges, one from each of the Allied nations. You had Sir Geoffrey Lawrence from the UK, who served as the president of the tribunal. He really lent it the gravitas of British judicial tradition.
Right.
And then the other judges, Francis Biddle for the US, Henri Donadieu de Vabra for France, and Iona Nikitchenko for the Soviet Union, they represented that necessary multinational composition.
And on the prosecution side, the leadership was equally crucial, especially the American lead, Robert H. Jackson.
Oh, absolutely. Jackson, who took a profound leave of absence from the U.S. Supreme Court to take on this role, he was really the intellectual and rhetorical heart of the prosecution. He was the most articulate exponent of the trial's legal philosophy, the voice communicating its immense stakes to the world.
And he had his counterparts.
He did. Alongside him were the other chiefs of counsel. Sir Hartley Shawcross for the UK, the French team led first by François de Menthon, and crucially, Roman Rudenko for the USSR.
The coordination required for those 4 systems to converge on a single indictment. I mean, it's just staggering to think about. Where did the biggest philosophical friction points emerge in drafting the charges? How did they land on that revolutionary indictment structure?
The friction was immediate. The Soviets and the French, coming from civil law traditions, were more comfortable with a system where the judges were involved in the investigation, where they essentially confirmed the guilt that was already established.
Which is very different from the Anglo-American system.
Totally different. The US and UK insisted on common law principles, demanding a clear adversarial process with strict rules of evidence. The compromise resulted in a kind of hybrid system, but the truly revolutionary part was the substance of the indictment itself. The 4 categories of crimes that form the bedrock of modern international criminal law.
Let's detail those. What was the first and maybe the most strategically crucial charge? The one designed to link the intellectual leadership, the so-called desk murderers, to the physical atrocities.
That was the charge of conspiracy. Participation in a common plan or conspiracy for the accomplishment of the other 3 crimes. This was Jackson's legal silver bullet. It was designed specifically for the men who gave the orders but never, got their hands dirty.
I see. So the key insight here was that this charge was crucial for securing convictions against the planners and designers, the evil architecture of the regime, so to speak.
Exactly. It allowed them to prosecute the men who designed the gas vans and mapped out the forced labor camps, even if they never pulled a trigger. It was about holding senior officials, who were entrusted with broad discretion and exercised great power, individually accountable for the crimes committed by those they controlled.
So it transcended the individual act of murder and targeted the criminal enterprise itself.
Precisely. If you could prove the conspiracy to wage war and commit atrocities, you implicated everyone involved in that planning structure. Which leads us directly to the second and arguably most controversial charge.
Which was crimes against peace.
Crimes against peace. The planning, initiating, and waging of wars of aggression.
Why was that one so controversial? Weren't aggressive wars already considered, morally wrong?
Morally, yes, but legally, no. Not in the sense of holding individuals criminally liable for making the choice to go to war. Before Nuremberg, initiating a war was generally considered an act of state.
Something governments did, not something people could be prosecuted for.
Right. The IMT indictment specifically noted that this charge involved the violation of 9 separate treaties, including the Kellogg-Briand Pact of 1928, which outlawed war as an instrument of national policy.
So the Allies are making the argument that aggressive war itself was inherently criminal.
Absolutely. Jackson argued that war inevitably involves a course of killings, assaults, and destruction, and that to plan such a war was therefore a crime. The goal of the trial was to strip war makers of any defense they might have previously claimed, to establish that the choice to start an illegal war negated any legal protection for all the subsequent acts carried out during that war.
Okay. So then moving on to the third charge, which dealt with the more traditional definition of warfare violations, just on a grotesque scale.
That would be war crimes. This covered the classic violations of the existing laws and customs of war, the Hague and Geneva Conventions.
Things like deportation of civilians to slave labor, killing of hostages, wanton destruction.
Exactly. Ill treatment of prisoners of war. While these were established principles, the scale of the systematic cruelty meant they were crimes of an absolutely unprecedented magnitude.
And finally, the fourth category, the one that stands as arguably the most significant contribution to human rights law,
Crimes against humanity.
which was defined as murder, extermination, enslavement, deportation, and other inhumane acts or persecutions on political, racial, or religious grounds committed against any civilian population.
A definition that was essential for addressing the systematic terror that preceded and accompanied the war, particularly the persecution of the Jews and other groups within Germany itself before the war even started.
But this charge came with a massive, politically sensitive caveat, didn't it? The final charter limited the tribunal's jurisdiction over these crimes.
That's the critical legal nuance. The definition was breathtakingly broad, covering persecution against any civilian population. However, the final version of the IMT Charter limited the court's jurisdiction to those crimes committed in connection with a war of aggression.
So they couldn't prosecute internal crimes that were completely unrelated to the war effort.
That's right.
Why that constraint? That seems to undercut the moral weight of prosecuting purely internal acts of state terror.
It was a necessary political compromise. It reveals the real politic that was going on, even amidst this global push for justice. The sources are explicit about this. Both the United States and the Soviet Union had severe reservations about giving an international court unlimited jurisdiction over a sovereign government's treatment of its own citizens.
Wait, you mean the U.S., fresh off the war, was worried about its own domestic practices?
Indeed, the U.S. legal team was acutely sensitive about the Jim Crow system of racial segregation. They worried that unrestricted jurisdiction over crimes against humanity might, in the future, allow an international court to investigate American racial policies.
And the Soviets, of course.
The Soviet Union certainly did not want any scrutiny of its own internal purges or its treatment of its citizens in the gulags. So the IMT established individual accountability for these massive internal crimes, but only when they were demonstrably part of the Nazi regime's overarching conspiracy to wage aggressive war. That compromise was the price of getting the IMT established at all.